Hi, James Polk here with Apex Law Service, and today we're going to talk just very briefly about DUI blood draws and when they aren't actually part of the exigent circumstances and required by law for a law enforcement officer to obtain, and therefore when they are not required, there is no real argument that the prosecution can make about administering a blood draw against your will because it's a violation of the Fourth Amendment. Now, one of the main things is if you go to the station and you do give a blood draw willingly, that's one of those things because of how the DMV works. You can lose your license if you refuse a test. A lot of people willingly give the blood, so you kind of have to have unwillingly been administered a blood test. So one of the newest cases that came out in the last, about a month ago, month and a half ago, Supreme Court case. It is Mitchell v. Wisconsin, and it was taken up on certiorari by the Supreme Court about the implied consent issue. And in an implied consent state, you have, by virtue of driving with a license, you've implied your consent to undergo an alcohol or drug test. So this person was given a breathalyzer and then they passed out in the back of the car. They were taken to the hospital and given another blood test. They wouldn't come back to. And they argued that it was a violation of their Fourth. Well, it was a plurality decision. There was actually one justice who did not want to really speak to the issue because he felt that the rest of the Supreme Court sidestepped everything and made it about the exigencies of the case rather than the implied consent issue. But the basic ruling was that, yes, it is allowable to give an unconscious suspect, a future defendant, a blood test when they're unconscious. So what you have to do with one of these motions to exclude blood evidence in a DUI case is that you have to show that the law enforcement officer willfully and knowingly violated the Fourth Amendment rights of the person who did not wish to have their blood drawn. So there's a few different cases in here. McNeely is the main case, and it's argued with Schmerber, but this new Mitchell case kind of talks about McNeely and Schmerber enough to where people are going to start referencing it since it's a new Supreme Court case. The exigency of there being a suspected or perceived amount of alcohol in someone's blood is not necessarily full enough of a requirement for there to be an actual need. Just the presence of the alcohol doesn't actually create the exigency is what I mean. So if there is no actual accident or injury, that's part of the totality of circumstances that McNeely talks about. Schmerber kind of said it to where there was only the exigency for the conviction and the need to get a blood draw before the alcohol disappeared. They can be very, kind of involved motions. So we do these different types of motions. We have to look at the specifics of the case, and every case is different. So we apply the case law. Generally, the case law that's quoted in this blog is some of the most important case law. So we have to compare and contrast how your case and these cases are similar and slightly different, and then we make the argument that your blood test should be thrown out. So we do that for your attorney. Attorneys come to us, and we also bring clients who come to us first to attorneys. So we do these motions both directions. Look forward to helping you with a very touchy situation, helping you move forward with your life and get beyond this situation where you got arrested and charged with a crime. Thanks again for tuning in.